gathered here today for the E.W. Barker Center for Law and Business distinguished visitor lecture by Professor Vikramaditya, Khanna, from the University of Michigan. I've got 5 things to say, except that I'm going to take a bit of time with this because just as when you get old enough and you're confident enough not to write it out, your memory goes, right? So you've got to write it out. But then after writing it out, you find you can't look at the words very carefully or clearly. So it's going to take a while. And I'm also going to take a while because it seems that there's still quite a few people registering out there, and we're going to let the stragglers come in slowly. But I'd like to say something first about the E.W. Barker Center and Mr. E.W. Barker himself. And I'll try to relate it to Professor Khanna, right? Many of you will know that Mr. Barker was one of the most outstanding young lawyers in Singapore after the Second World War. He went off to Cambridge on a Queen's Scholarship in 1946, right after the Second World War. He was our first law minister, and he served for 24 years. But I think the thing that we remember most about Mr. Barker was that he was one of the most outstanding sportsmen that we ever had in Singapore from a very young age. And so that youthful image of Barker is what we have. And it's relevant to us because Professor Khanna is the youngest tenured professor in the history of Michigan, right? Law school, or is it generally? Law school, right? So I guess we can't beat the mathematicians who need to get their tenure earlier because they forget what they do by the time they're 35. So Vikram comes from serious pedigree, right? He is very outstanding. But what I guess interests us with respect to Professor Khanna is that he teaches a course on white-collar crime in Michigan, which is quite unusual because you don't really hear the Ivy League schools, the very top national law schools teach subjects like that. And yet, given what we have seen in the past few years, this is probably one of the most relevant areas for corporate practice litigation, right? So white-collar crime is one of his areas. For those of us in corporate law, we've also followed Professor Khanna's works for a long time. What actually brings him to our attention more than anything else is the fact that he co-writes the book on business organizations, the most leading textbook in America, with Professor Reinier, Kraakman, right? Who I think you must have studied under him, taught me as well in 91, 92 before you. So in company law, he is very, very well known. And then the third prong of his research is in Indian law and Indian business and corporate law in particular. And that's where he and Professor Umar Khan, right? It's not appropriate for me to say so, but he's just been promoted today. Professor Umar Khan, they're writing the definitive textbook on Indian company law, right? And given the importance of India, the future, the now even, that's a textbook that I think everybody is waiting for. Well, today he's going to speak to us. He's going to combine everything that he's done in white-collar crime, corporate law, and talk about securities regulation and how it applies in the crypto space. And we know how relevant that is today. We had the FTX issues last year. Binance was just a couple of weeks ago. And a lot of that involved unregistered securities. And so I think without further ado, I'll call Professor Khanna up here to tell us more about this area of the law. Thanks.
Thank you, Hans, and thank you, everyone, for inviting me here. I'm delighted to be here. Before I start, I'd like to express my thanks to both Professor Hans for his gracious introduction and the pleasure of having lunch with him over the last few days, to Professor Umakant, who, of course, is a longtime collaborator and a great friend, and was kind enough to be part of the team arranging this time here in Singapore. So today what I'm going to speak about is securities regulation and crypto asset markets. And of course, crypto assets have attracted a great deal of attention over the last, I'd say, 5 to 10 years, both good, bad, and otherwise. What I'm hoping to do in today's talk is to talk briefly, just to introduce people a little to what are crypto assets and why they might be valuable, and then to begin to launch into thinking about what areas of law do they implicate. And I'm going to spend most of my time focusing on securities regulation, but with a policy lens as well as a legal lens. Much of the analysis in this area has been dominated, I would say, by sort of a doctrinal or legal analysis, which is wonderful. But I think a lot of the questions that are raised by crypto assets and digital assets more generally push us on policy issues and on functional analysis. So I'm going to try to actually bring that in a little bit more explicitly into the analysis to start thinking about how would we want to regulate these sorts of products? What issues do they raise that are similar and different to standard securities regulation? And how might that lead to somewhat different outcomes? I'm going to spend some time a little bit just talking a little about what is US securities regulation? What is it designed to do? That might seem like a very basic topic to start with, but I've often found that when you're looking at newish areas, sometimes going back to the basics is often helpful. So we'll spend a little time talking about what are the key concerns of US securities regulation. That's primarily asymmetric information and conflicts of interest in raising capital. And of course, attempts to, on the other hand, try to curtail some of the regulatory burdens that are put forward by securities regulation in the US. The primary response of securities regulation is to force out information, compel disclosure, and to police how well you actually say it, and sort of regulating conflicts of interest. We'll talk a little about the securities regulation structure. That is, we have a very broad definition of securities. We cast the net broadly, and then we try to rein it in with exceptions so that we don't impose large regulatory burdens. And that leads into our core legal question for crypto assets, which is, are they securities? And we actually have recent case law on this and regulatory moves. And what I'll suggest to you is that the case law is helpful but not complete. But when you bring in a policy analysis, you actually start asking somewhat different questions, and you come up with somewhat different answers. And that's really where I'll lead to, which is, do crypto assets really raise the same kinds of concerns as standard securities? And what I'm going to suggest is actually they sometimes do and they often don't. And perhaps more importantly, the regulatory structure that's present in securities regulation doesn't really work very well for too much of crypto assets. That doesn't mean they should be unregulated. It simply means that the regulatory structure you might adopt may look somewhat different than what we see in securities regulation. And that will lead us to talk about some of the emerging regulation we see throughout the world, in Singapore, the EU, and elsewhere. And that will then lead me back to talk about how some of the lessons or insights we may gain about crypto asset regulation in securities may be useful to thinking about crypto asset regulation in other areas of law, thinking about money laundering, privacy, and the host of other areas that cryptos seem to raise almost on a daily basis. All right, so what are crypto assets? Now, I think most people in this room are probably familiar with what they are, but I thought it's a good thing to sometimes start again with the basics. We've all heard of Bitcoin, Ether, smart contracts, Dogecoins, NFTs, and so many others, right? But before going into the details of them, I thought it's helpful to try to understand, why do people think these things are valuable? I remember the first time I looked at crypto and someone said they have Bored Ape NFTs. My reaction was, this seems like something a video gamer would do when they got bored, right? But when you look a little more closely at it, there's actually an interesting transactions cost argument for why these might be useful things. And I thought the easiest way to sort of sketch this out is to give a very basic example of what people think crypto assets, or digital assets more generally, might be useful in achieving. All right, so let's take, for example, a very simple real estate transaction. Someone wants to sell land, someone wants to buy land. Generally speaking, there are a series of things that need to be verified before that transaction can occur. The most obvious of which is that the seller actually has title to the land and that the buyer actually has the funds to buy the property. There are many other questions you might want to verify. What are the boundaries of the property you are planning to buy or sell? What are the conditions, of any, attached to the property? Now, we almost never really think about that much because so much of what happens in a property transaction occurs essentially behind the scenes. A good example is in the US, when you buy property, after finalizing the price and the property you wish to buy, it still takes an additional 4 to 6 weeks to actually take possession of the property. Now you might wonder, why does it take so long? We've agreed on everything. That process is actually the verification process. You have title agents checking whether the seller actually has title. You have mortgage companies affirming that you have the funds to pay for this immediately, etc. That's all occurring behind the scenes, but it does actually take 4 to 6 weeks. Most people estimate that these closing costs involve the use of intermediaries that probably represent between 5 to 9% of the actual underlying property price. So if you buy property of $1 million, you're probably paying in the range of $90,000 to $100,000 to deal with the closing costs, which are almost entirely verification costs. Now, why am I stressing verification? Because it turns out that the technology underlying crypto, blockchain, is primarily designed to reduce verification costs. And that's what its primary social advantage, in theory, is. All right. So blockchain, as many of you know, is a set of technologies that may reduce verification costs. If the information is digital, the asterisk there is because most information is not digital. Then blockchain can provide speedy, accurate, and often cheaper verification and rely less on intermediaries than, say, pre-existing technologies might. Using the real estate example, there are places where if you have digital property records, the time required to actually clear the transaction is not 4 to 6 weeks, but approximately about 45 minutes. The cost is substantially less. It's not between 5 to 9% of the property. It's approximately 0.001% of the property. It's essentially a rounding error. Now, when you reduce verifications costs, which is a subspecies of transactions costs, you have a number of effects. The most obvious is you reduce the cost of doing something, you get more of it, right? I've noticed that every time the price of milk reduces, I buy more milk, even though I don't actually like milk, right? It's just because it's cheaper. Similarly, you might have more transactions, right? Which of course benefits people who make their living off of doing lots of transactions. In addition, since you're relying less on intermediaries, the costs associated with those intermediaries declines too. Some of those costs are their fees, but some of them may also be the fact that intermediaries can become important bottlenecks in markets. Indeed, in the US, one of the key arguments about why big tech is considered to be more problematic these days is that they have essentially occupied a bottleneck intermediary position in many markets. People talk about Google being a behemoth in search and in ads, Amazon being a behemoth in wireless services. That's because they've occupied an intermediary position. All right, and perhaps even more fascinatingly, if you reduce verification costs, you might be able to actually enable the creation of new categories of assets that didn't exist before. The most common example of this, and I don't think it's necessarily the best example, but it's one that everyone sort of can grasp quickly, is resale royalties. So back in the day when I was a teenager, which I won't tell you when it was because I feel increasingly old every time I say so, back in those days, there were musicians who were very popular, as they are today. Let's take U2 as a band. I once bought an album, I bought a couple of albums by U2, and then after a decade, I sold them in a garage sale. When I resold those albums to someone else, U2 didn't get any of the royalties, right? In theory, maybe they should. Well, that's because the law had no way of verifying that I had actually sold it down the line, and there's no way for U2 or its record company, which in fact U2 actually owns, to recover the royalty. But with digital assets, there's a trail, as many people like to say, an immutable ledger of transactions that allows them to actually track those resales. A new asset class that didn't exist before. And that gets really interesting because what if you can actually start creating assets that weren't there before? Now, I say that the same way that someone talks about, creating a new type of food category that tastes good and is low fat. A great idea, but not easy to observe in reality, right? Beyond resale royalties, there aren't that many obvious examples yet, but one can imagine some. But of course, nothing is free in life, right? Even blockchain is not free. To do the kind of verification that's required under blockchain, you actually need entities to expend resources on doing those verifications, right? And they need compensation for that. Well, how do they get compensated? And here is probably the one place where I'll get a little technical in terms of what blockchain is. So blockchain typically comes in two flavors, private blockchains and public blockchains. Private blockchain simply means that there's usually one or maybe a couple of entities that control the verification process. A good example of this is when a big financial institution, such as a bank, let's say JP Morgan Chase, creates a coin, a crypto coin, for doing its own transactions. Indeed, JP Morgan does have a JP Morgan coin. Goldman Sachs has a Goldman Sachs coin. They don't trade on the market, right? They're used internally within these entities to basically do transactions, right? So you may go to JP Morgan and want to send money from one country to another and pay 2% or whatever it is. They're not paying anything close to that. They're using these coins to basically do these cross-border deals at a very small fraction of the price they're charging you. It's good to be a bank, right? However, the way they're verifying the transactions is they pay the people to verify the transaction using a private blockchain. These are people who will basically look at encrypted transactions, decode them, re-encrypt them, and say whether they're valid or not. But that's all occurring internally, and they're being paid typically in cash or stock or something like that. Okay. The concern here is basically JP Morgan becoming a big intermediary in yet another market, let's say. All right. Public blockchains, and that's where crypto is going to come in. We don't see crypto in private blockchains, generally speaking. In public blockchains, there is thought to be no central party controlling verification. Now, for a lot of people, this is intuitively not obvious what this looks like. Imagine Wikipedia, but made in some other kind of transactional context. People put things up there, and then other people out there confirm whether that information is accurate or not, right? There are some differences of significance, but this is maybe the easiest example one can have. To verify transactions on a public blockchain, you actually go through a verification process. And the people who verify these transactions are typically called miners. They get paid usually in digital assets. And here's where the fun starts. They get paid in digital assets, usually of the transaction they're verifying. An excellent example of this is Bitcoin, right? When you have a Bitcoin transaction, the people who verify the transaction, the Bitcoin miners, if they succeed in verifying it before anybody else, their payment is some fraction of Bitcoin. Now, you don't have to be a terribly technologically advanced person to understand that if I'm getting paid in the currency that I'm verifying, there are potential conflicts of interest there, right? I have an incentive to want to maximize the number of transactions because I'm going to get paid more and more that way in that underlying transaction, which is kind of interesting. If I got paid in Coca-Cola cans for verifying Coca-Cola can transactions, I would want to verify a lot of Coca-Cola can transactions. That simple. All right. When you have this kind of a structure of a blockchain being used to verify transactions, typically the digital asset is the crypto. And the value to the people who are verifying it exists because there's a lot of use of the underlying crypto and or a lot of trading in it. They can trade it on the markets, make money from it. They can use it or sell it to someone who uses it and encash it, turn it into resources for themselves. So for crypto to actually have value, it needs to be used and or traded. And therein lies the rub. Right? That is where much of the regulatory issues are going to arise, because how are they traded and how are they used are going to be where the value is derived and where the conflicts are most likely to come up. And of course, you can already see some of these concerns, right? If you read the newspapers and the magazines on crypto, you see fraud allegations, a lot of fraud allegations. When I first started doing crypto, it was because I was interested in money laundering at the time. I'm still interested in money laundering, but crypto has taken up a little bit more of my time. All right. This kind of analysis kind of lets you know where crypto may be useful and in fact where it's less likely to be useful, which is perhaps the more important point. Crypto is going to be most useful when verification and intermediary costs are really high and it's difficult to get people to verify using cash or other methods of compensation, right? That seems like actually a pretty small set of things. Right? Why can't you pay verifiers in cash? What's stopping you from doing that, right? As the private blockchains do, for example. Again, this must be balanced. Whatever these benefits are, they must be balanced against the potential conflicts of interest that you see in crypto and the risk for fraud. That's where the law comes in, right? When I teach white-collar crime, I typically dress in all black because I like to be the angel of death. Today, I thought I wouldn't be that bad. I'd just go dark blue. The concern here is you need to use some kind of legal structure to reduce the downsides of the conflicts associated with relying on a payment structure that incentivizes people to do too much of something, essentially. Okay, I'm going to come back to that in a little bit, but just to make it a little simpler for analysis, let's assume that there is some subset of transactions and business issues for which crypto is actually going to be useful on net, right? And then let's explore how we can regulate it so that it becomes less costly to us and potentially even maybe more useful. All right, we'll come back to critically examining crypto's usefulness a little later. Okay, so securities regulation. Why start there? There's so many areas of law that could be implicated by crypto. The reason is simple. Given the importance of trading cryptos to the crypto asset markets, it seems to make sense to start with an area of law that deals with trading. Securities regulation is the quintessential trading law. That's where we're going to start. All right, so what is securities regulation primarily concerned with? I always find when I teach securities regulation and I begin the course that way, the students give me a blank stare, as if they've never thought of the issue, which is kind of amusing. The key things that securities regulation is worried about is largely related to issues arising from the issuance and trading of things called securities. The biggest one, of course, is asymmetric information. The company that's issuing stock and its executives know more about their company's prospects than the investors they're approaching. That level of difference in information can create really bad incentives, sometimes called adverse selection in economics, sometimes called moral hazard. The easiest way to think about it is if you know less about something than someone else, they might exploit you. That seems almost straightforward. The way we try to address this is by forcing disclosure of information by the law, compelling that disclosure to come out, and then making sure that people don't lie or mislead by saying, if you lie or mislead, we will penalize you through the anti-fraud rules. Okay, and at least in the US and in many other parts of the world, those are often very large civil penalties and increasingly criminal penalties. Again, it goes back to my theory that everything comes back to white-collar crime. All right, so, but the problem with this particular way of approaching regulation is that it's ex post, right? The times you recover are when the company, the issuing company, doesn't have money. Well, that creates its own problem, right? Which is, I want to recover from a company when I've lost money, which is when they've lost money. How much are you going to recover from someone who you know doesn't have money? Not much. That forces a peculiar issue that arises in the securities markets and in a lot of interconnected financial markets, which is when something bad happens, the primary bad actor doesn't have enough money to compensate you. So how do you recover from that? You target third parties who can influence the primary actor and make them active in the process of regulation, typically called third parties, gatekeepers. In the securities markets, we're usually thinking about exchanges, brokers, underwriters, lawyers, accountants, all the professionals who kind of service that sector. Okay, so we decide to impose duties and obligations on them to basically trigger them into monitoring even more closely whatever they're doing in this securities issuance process. But of course, gatekeepers can have conflicted interests too. And so we police that by having yet another second order set of rules, not just forcing disclosure by the issuer and affiliated parties and penalizing you when you lie, but we're going to now have obligations on the third parties, brokers, exchanges, and others affirmatively to do things and also to prohibit them from doing certain things, right? Okay. The cost of this kind of layered regulatory structure can become increasingly high over time. So one of the things securities regulation tries to do, in addition to compelling information and policing your behavior and having a second layer of regulation, is to say, let's not make you subject to all this regulation so that you decide not to raise capital easily, right? Or you do it less often. Securities regulation in the US and elsewhere, as I was mentioning here, address these often conflicting concerns by defining what it covers and then exempting out things where they think the concerns are not very serious. The best known example of this is what they call private placement of securities. When you decide to sell to very sophisticated investors who may know more than actually the issuing company about how to trade securities, securities laws don't feel as much need to force out that much information or to impose strict restrictions on brokers and exchanges. So you've got this kind of accordion-like feel to how securities regulation works, which is when we think you're targeting very vulnerable groups, we attach much more obligations on you. When we think you're targeting more narrow groups, we impose less significant obligations on you. Okay, now that's all nice sort of conceptual background to thinking about securities. How does this apply to crypto? So the key question here is basically, when do crypto assets become subject to this regulatory regime? That is, when do they become a security? So the legal answer is simple, actually, which is US securities regulation asks first whether the title of the thing or the item is on a long statutory list under the Securities Act and the Securities Exchange Act. And if it is, it includes things like stocks, bonds, shares, and so forth, then it's presumptively treated as if it is a security. You can rebut that presumption, but typically it's just treated that way. If it isn't on this long list of things, then you have to fit it into something called an investment contract under something called the Howey case, which is, I think, from the 1920s. So we're going to use case law from a century ago to assess cryptos. Right? That's not necessarily a bad thing. I like old things. Indeed, as I get older, I like them more, it turns out. But generally speaking, a lot of people were often worried that how much can this be useful? All right, so Howey basically asked whether the thing is an investment of money or other thing of value in a common enterprise with the primary object of profit, primarily from the efforts of another. I've underlined that because that's going to be the critical issue. And where no other existing regulatory regime applies. Most people forget that fifth one. Why is that? Well, they don't teach SecReg, that's why, but that is actually a significant one. All right, so what do the case law and regulation say about crypto? So there's precious few decided cases, but there's lots of activity. The case that most people have sort of attached to is the Ripple case. And one thing to note about the Ripple case, that was a preliminary decision by a district court judge in New York. The precedential value of this is slightly above 0, I would say. If one wanted a technical legal analysis, 1% above 0. Now, why do I say that? It's because it's going to be appealed for sure. I have a suspicion that it will be overturned at least in part, if not fully. But what does it say? It says almost nothing about Howey except that we need to think about the efforts of another, and then proceeds to say that that differs for institutional and retail customers purchasing crypto. That institutional investors who purchase crypto are doing so with a reasonable expectation of profit, which means it fits the Howey test, that fourth prong that I'd underlined. But retail investors are not expecting profit. Really? Why are they buying? Presumably not for aesthetic feel. That just seems odd. Nonetheless, that's the line the case takes, is that institutional investors are reasonably expecting profit, so it's a security for them. For retail investors, it's not. Now, as a legal matter, this is the first case I've come across where the identity of the purchaser matters to the definition of whether something is a security. Generally speaking, the identity of the purchaser matters not in whether something is a security, but in deciding how much of the full extent of the federal securities laws we apply. The more sophisticated the investor, the less the securities laws really constrain the behavior. Notice what's happened here in Ripple. They've moved the issue of who buys it from whether you get the full extent of the law to whether the law applies at all, and then they've inverted it, which is institutional investors now get more protection than retail investors. I have seen no reading of the securities laws in any country where that makes much sense, right? It's the retail investors that presumably are most concerned about being defrauded than the institutional ones. In any case, one of the reasons I think the case is likely to come out differently as it goes through the appeals process. A case that has attracted less attention, but came out approximately a month after Ripple, was the case dealing with Terraform, the Luna, crypto, right? And here, that case actually ignores who crypto was sold to. In fact, specifically says that the Ripple case we disagree with, right, Judge Rakoff, and thinks that actually all of these are going to be securities. But here's a funny thing. Although I think his analysis of whether the identity of the investor is correct, actually the case law is a little bit weird on this. Not all cryptos are actually securities. The two best known cryptos are actually accepted by almost all regulators as not being securities, Bitcoin and Ether. So how do we now figure out when something is in the Bitcoin category and not a security, and when it's in the rest of the world and is a security? Terraform doesn't really give us an answer to that because, again, it's an early stage decision. So we start to think, okay, maybe the regulators can provide us with some guidance. Here are the regulatory responses thus far. The SEC treats most cryptos as securities except Bitcoin and Ether, right? But some commissioners, Commissioner Henson in particular, has a very nice speech that says crypto assets can be either securities or not securities. And what's interesting is his analysis is very policy-driven. He concludes, in a very kind of, I think what people might have thought somewhat unusual, that crypto assets can actually start out being a security, and then as they're used over time, can actually become not a security. And to make matters even more fun, you can have the vice versa situation too, which is you can start out as something that is not a security, and as it's used over time, it can become a security. Okay, now, I suspect when people read it the first time, they're like, yeah, we've seen cases where how a thing is marketed influences whether or not it's treated as a security, right? You market to the general public, right? You don't limit who can buy it and who can resell it. It's going to be treated as a public offering. Fair enough. Here, however, it's not how you're marketing it. It is how it is used after it is sold. So that what the investors do with it is determining its status as a security or not. I have not seen that approach taken anywhere yet. Conceptually, I think I understand where he's going. His argument is that federal securities laws are designed to deal with asymmetric information and conflicts of interest. If over time a crypto is more decentralized, by which they mean its profits are determined not by the people who issued the crypto, but by the market, then forcing the issuers to push out information that they don't have seems almost silly, right? The issuer doesn't know what the market is doing per se, and in a decentralized market. So what would imposing disclosure obligations on the issuer actually do? They don't know what they could put forward to you. Conceptually, I understand that, but it doesn't fit within the definition of security. In fact, it would make the definition of security quite unstable, that it would depend upon what the investors did with the security to determine whether it's a security. That seems a very unusual path to follow. But I think it does highlight the fact that thinking about this in policy terms is going to be actually quite important. Commentators, right? As an academic, I always love to hear what commentators have to say. Commentators basically stick to the legal line and say, well, crypto assets, the value of them is often not determined by the issuer, and so they don't meet Howey's fourth prong. I find that argument by itself to be quite unconvincing. Why is that? There are many things out there that people buy and sell that are considered securities where the issuer has very limited control over what the thing is or the value is. Probably the best known example of this, and certainly the most dramatic, are viatical settlements. This is where people have life insurance policies and a subset of them develop terminal conditions. And there's a market where you can basically take your insurance policy in this context and sell it, right? People will buy your insurance policy, you assign your life insurance to them, and they're basically taking a bet on how long you're going to live. It's a little gruesome, I agree, a little ghoulish, but life is not always pleasant, right? So what's happening here is that the person who's issuing the viatical security is actually making a guess based on estimates of life expectancy for your condition, your overall health conditions, how long you're going to live, and they then pay you a lump sum upfront payment, and they get assigned your insurance policy. Okay. Now notice how this happens. After that initial decision and metric that they use to figure out how much they think they should pay you, after that, they have absolutely no influence over when or how they get paid, unless they like murder you or something, which seems highly unlikely in this context. Yet, even though they don't have control over the final outcome, viatical settlements are quite clearly securities. They've been held to be securities more than once, right? So I don't really buy the argument that, oh, well, the assets are, the value of the assets are not determined by the issuer long-term as a fully, answering this question. I think really what that fourth prong of Howey's about is that if the investor's payoffs are influenced by what the issuer does or did, then the issuer has some obligations under federal securities laws. What those look like will depend on whether you can fit exemptions or not, but I think the idea is there's asymmetric information here that can be addressed by disclosure. Okay, so these are all really interesting, right? You can talk, I love the sort of the debate on the head of a nail about whether this is security or not. But what's fascinating is most of these approaches don't actually address any policy considerations. These are different kinds of analyses looking at different kinds of techniques. Let's do some policy analysis, right? Let's start with asymmetric information. In the crypto markets, looking at public blockchains. Okay, step one. In theory, decisions about a crypto asset on public blockchains are visible and transparent. So what's the asymmetric information? If they're published in a public forum, that's disclosure before anything. Or what would be the need to force more disclosure? That's the typical argument that you get in the crypto community. Right? But there's always two hands. Right? On the other hand, it turns out that you often don't know who's trading. Right? Here's the funny thing. Go and ask people who trade, who's actually trading the cryptos? It's often hard to identify, partially because of data privacy concerns, but also just because people own it through a series of intermediaries. But it may be actually quite important information to know who's trading. I'll talk about that in a minute. You often don't know whether there are side deals between the people who are trading, right? And other sorts of questions like that. So although information about the decisions being made on a crypto are public and visible, which they aren't always in securities, these other matters are actually still missing. So there is asymmetric information. It's just different than what you get in the typical security, right? Indeed, my colleagues and I, Professors Prabhala and Manjupuri, ran a survey, nationwide survey in the US last year, surveyed about 20,000 people in the general public to find out what are they interested in when it comes to thinking about investing in cryptos? Like, what information would they like? Do they think regulation is valuable? Much to our surprise, I'm a lawyer, so whenever I ask a question about is regulation valuable, I expect the answer to be yes. The vast majority of respondents said they don't think regulation is terribly useful here. Interesting. They did, however, say what they would like to know is who's using crypto assets. In particular, are big institutions and government using it? And what they mean by use is, do they use it in their day-to-day operations? Does the government allow you to use the Bitcoin to pay tax? Does the healthcare system use digital health records fueled by crypto to make themselves run more efficiently? They wanted to know that. They also wanted to know, basically, the identities of those designing the digital assets. But they weren't particularly interested in their compensation structures or other things that you typically see in federal securities laws. So there is asymmetric information. The investors do care, but it's not the same kinds of information that you have in federal securities laws typically. Suggesting that compelling disclosure might be useful, but what you compel is actually perhaps more important than the fact that you do compel, which intuitively makes sense, right? Yes, there's asymmetric information, but I want to know about the things that matter to me in investing in this particular company, not what matters in some other context. All right, but that's not the only policy concern. Gatekeepers. In my view, this is actually a much more difficult issue, right? When you think about how people sort of pitch crypto to you, they talk to you about economic freedom and that you don't have to deal with intermediaries. You can believe it or not, but here's the fun thing. Most of federal securities laws presumes a very elaborate intermediary structure. All of gatekeeper liability is premised upon there being intermediaries, right? If there are no underwriters involved, if there's no investment banks, if there's no lawyers, then when the issuing firm goes bankrupt, all the investors have nowhere to get compensation from, right? All right, so a strategy of relying on gatekeepers, as we do in securities laws, makes a great deal of sense when you have intermediaries. This is like almost so basic, it seems like you don't need to say it, but maybe it's worth saying. You need to actually have them, and here's something more important. Those intermediaries need to be actually able to influence the behavior of the issuer. Our goal is to get certain kinds of information out there that are verifiable and accurate. That's what the gatekeepers are helping us with. They can only do that if they can influence the issuer's behavior. This maps on really weirdly to crypto markets, right? Who are the intermediaries here besides the exchanges? And there's so much off-exchange trading, right? There's so much off-chain trading. Forget about off-exchange trading. They don't appear that well positioned to actually influence disclosure. That suggests we may have to think a little differently about third-party and gatekeeper liability when it comes to crypto, because we don't have those kinds of intermediaries and they don't have as much influence as they do in the securities context. So much of the regulatory scaffolding that we see in federal securities laws is using those intermediaries as regulatory touch points, which we don't have here, or at least they look different. Here's an example, right? In a series of recent settlements, various government agencies have imposed liability on the members of decentralized autonomous organizations, the DAOs, which are the entities that typically create the white papers nowadays for many of the crypto coins. Okay, so are DAO members in a good position to be monitors of what everybody is doing? They're like, well, kind of, because they designed the crypto. Yes, but a lot of the harm is not in how the crypto is designed, it's in how it's used, right? They don't necessarily have a great deal of influence on that, but who does have a great influence on how these things are used? And that's usually the response I get, crickets. It's unclear who does. The people trading in it, yes, but the people who are big traders are not always the same players in each transaction. The value of an intermediary is they're there all the time. They're consistently present where they can take a role in influencing behavior, not just once in a while. That makes thinking about the gatekeeper strategy particularly problematic. And in fact, that makes it hard to apply from a policy perspective the architecture of securities regulation onto crypto. In my view, that's actually the much harder issue than the asymmetric information issue. Asymmetric information, at least if I can identify what information they want, I can craft rules to push that out. Here, I don't know who the intermediaries are to police what's going on. Or at least I don't know all of them on a consistent basis. Finally, the other conflict of interest here, or the other big regulatory problem is, there's actually, and our survey sort of finds this too, fairly low levels of participation in crypto asset markets by retail investors. Depending on how you count it, between 5 to 10% of a retail investor's portfolio is in crypto. That's not a great amount. That means that a lot of transactions are occurring with bigger players who might know each other and are likely to understand trading patterns better than retail investors. The potential for conflicts of interest here is almost screaming out at me, I need headphones to block off the noise. I suspect there's going to be a need for regulation on this side. Okay. All right, so the analysis here suggests that current securities rules probably need much adjustment before being applied to crypto asset markets. Okay, well, one thing an academic can do is point out what the deficiencies are of a particular regulatory structure. I always like to go a little bit more, and I'll suggest something here, which is, here's one approach to thinking about regulating trading in crypto assets. I caveat this by saying it's in very, very early stages, largely to spark discussion. So if you're critiquing it, I appreciate that. How about this? Let's first make an assessment about whether the crypto asset is being used to raise capital, like an initial coin offering, right? Now, you could use something like a Howey-like test, but I think let's just focus on functional things here, right? Is the goal here really investment, right? And is some part of the return being determined by others besides the investor? I think if that's present, there's going to be some asymmetric information, and that will be at least the hook to get you into talking about compelling disclosure. Okay, if that is there, then ask, what sorts of information do investors really want? You could use our survey or any other survey as a starting point. It strikes me that the fact that they're interested in who uses the crypto asset and who designed it is a good place to start. That's really almost proxying for its likely productivity in the future. If none of the big players are using it, how useful is this thing, right? Might make you a little skeptical. That could be one place to start. Well, who should we impose duties and liabilities on? Remember, I told you this, I think, is actually the harder issue. So because they're different than in those securities markets, and their ability to influence the issuer is actually, I think, less, I'm not so confident that we'll find easy to attach third parties and gatekeepers here. You could look at people who are frequent participants in the market, but you impose liabilities on them and all of a sudden they become less frequent participants in the market, right? That's one. They do the equivalent of shadow banking, right? You put a lot of obligations on banks and all of a sudden everybody goes to where it's not so much in the sunlight. Well, then who do you go to here? I don't have a strong sense. I think exchanges seem like the most obvious choice, but crypto exchanges are a weird beast, right? Coinbase and Binance and all these things, these are centralized exchanges that are selling you a product where everyone tells you the future is decentralization. And you're a little like, are these really the people I want having regulatory authority or sort of like monitoring authority, they themselves are saying they are the dinosaurs in the business. It's kind of an awkward way to impose liability. Well, what about then the decentralized exchanges like Uniswap? Yes, but the point of Uniswap is that there's no one monitoring. That's kind of the goal, right? They have very basic qualification standards. So the notion that they have a lot of influence, slightly puzzling here, right? I'm actually inclined to think that it's not obvious that a gatekeeper strategy will work very well here. Or at least it's not obvious who the gatekeepers would be. In that context, it strikes me that actually ex-ante regulation might not be a bad path to pursue. We see that in securities laws in some countries, not so much in the US. In many countries, in some areas, to actually issue stock, you need to show for the last 3 years you had a profitable record. Your owners have to actually commit not to sell down their stake for a certain period of time, et cetera, et cetera. That's ex-ante regulation, right? Making sure people are available to be attached for liability purposes. You are basically creating gatekeepers out of existing participants in the market. It's very hard to create gatekeepers out of thin air because then they disappear into thin air, right? Not to underscore the obvious. When they're there and doing something, you might be able to get them on board. But this is a different approach than what federal securities laws actually typically follow, right? All right. Now, of course, the alternative is if it's not being used to raise capital, then I don't think it raises many of the issues associated with securities laws, but it might raise other issues dealing with other areas of law, privacy, money laundering, et cetera. We'll talk briefly about that in just a couple of minutes. Okay, so what are countries actually doing, right? This is fun to do because there's almost a different approach everywhere, it seems. So the US does not have specific legislation yet. There are lots of draft bills. Those of you familiar with the US legislative process know that there are thousands of bills out there for almost anything, it seems. Regulatory agencies are really assertively pursuing enforcement actions, and that's generated a great deal of discussion and criticism. The UK, the Financial Conduct Agency, basically regulates digital assets it considers investments, but things like Bitcoin and others seem largely unregulated, except in a certain money service provider sense. The EU is coming up with its markets in crypto assets regulation, which fully goes into effect somewhere between June to December of next year. There's a lot of bells and whistles here. I won't go into all the details unless people are really interested in the bloody details, but in essence, what they're doing is they're adopting a licensing model with rules designed more for crypto. I understand the licensing model. I'm skeptical that by itself it will work exactly for the reasons that I'm not sure gatekeeper liability will work. The licensing model presumes that you have an entity you can attach as a gatekeeper, the one who gets the license, right? And I'm just not sure who they think are the licensing folks. I'm assuming, based on what I've read of MiCA, that it's the exchanges. I wonder if that's really the best place. It's certainly not a crazy place to start, but I don't know if that's really the most sensible place to start. Hong Kong, of course, is developing a new regulatory regime via licensing, it seems. India seems most concerned about the financing of terrorism, which is really a kind of money laundering concern. They've imposed a tax on trading crypto that is actually quite large, that in many ways is really designed to basically reduce the amount of transactions in crypto. Singapore, I won't tell you what Singapore is doing because you all probably know better than me, but it seems that here crypto asset trading is legal, but it's much more focused on money laundering concerns, and if you're dealing with something that's a digital representation of another asset, then it's a security. All right, now, having talked this much about securities regulation in my last few minutes, I do want to talk a little bit about other areas of law, because I don't want to give the impression that just because I teach securities regulation that I think it's the only important topic out there, right? So of course, securities regulation I think is important because for crypto to work, it needs to be traded. And this is the primary law that governs trading. Commodities markets laws do it, but in many countries, commodities and securities are regulated by the same entity. In the US, they're not. If you're interested why that is, we can talk later. All right, but here are some other areas of law that are actually important and where policy analysis, I think, would actually be really important in thinking through what kind of regulatory structures we would actually want. Data privacy and blockchain. I love this one because they're so obviously opposed to each other, right? The point of blockchain is immutable ledgers that track every transaction. The point of data privacy is don't track every transaction. All right, those are opposing forces, right? How do you deal with opposing forces? You have to find a balance point, right? Well, how do you balance? Some kind of explicit policy analysis is going to be useful, thinking through what is the privacy concern we're worried about here, right? The most natural place to begin thinking about this would actually be money laundering, where what you're worried about is the privacy superseding the concerns you have that underlie money laundering regulation. Another, commercial law and so-called smart contracts. I'm told that the real denizens of the crypto world are excited about smart contracts, right? Which, by the way, are not contracts. Anyway, they're excited about it because it means that the execution and enforcement of contractual agreements becomes more efficient. That's their belief. Fair enough. The only concern here is the way this typically works is something in the smart contract is set up that if the conditions are met, a trigger occurs. A lot of times these triggers are not automatic. They require some kind of third-party verification. Someone called an oracle. I kept wondering, are these people fans of Greek mythology that they're thinking about oracles? No, they love the Matrix movies. Go figure. It turns out that what you're really looking at here is a third party verifying the conditions are met and then immediate implementation. That additional step of the third party verification, to me, opens up the prospect for potential abuse and mistakes being made. One might have to think what kind of safety measures or tripwires you would want here, and the moment you put those in, the speed of execution will slow down. Right? It's almost self-defeating in some ways. There are other areas of laws too, but this is really just to give you a feeling that more explicit policy analysis would actually be useful here. I throw regulatory sandboxes up here because I hear that everywhere. Regulatory sandbox, let's try it. I think that's a great idea, but as with many great ideas, it's about implementation, right? I think learning how to return tennis serves the way Novak Djokovic does is wonderful. Am I going to implement as well as he does? I don't think so, right? Partially because I'm a Nadal fan, but that's a different story, right? All right, I'll leave that up for people to think about. Finally, I did promise, and I'm doing well, I think, time-wise, that I would come back to whether crypto is really worth it, right? I see this a lot when I talk to people who work in the crypto world or in the digital assets world, that, boy, this just seems crazy, right? I'm a little skeptical at times that not that crypto has value. I think it might have value in some cases, but I think the number of times or the size of this market may be a little smaller than people are imagining. Here's why. Blockchain is not the only game in town. There are lots of technologies that can be used to verify things, right? And whenever there are multiple ways to do something, the issue is always going to be about trade-offs, which is, yes, blockchain is very accurate, but do I really need accuracy for everything? How much accuracy do I need? I'll use the tennis example. My opponent is on that side of the court. Do I really need to hit the ball on the line there? It's okay if it's an inch or two in. It's just fine, right? I don't need to be that precise for certain things. Similarly, it may be the case that blockchain's cost for that extra 5% accuracy are massive, as an example. That makes me think that you really need to look at other verification technologies and assess their net gains for the situation you're looking at. When verification costs are high and intermediary costs are high, that's when blockchain is likely to be useful. That's just blockchain, right? Another thing is verification costs can be reduced, but sometimes that doesn't change anything. Why? Sometimes for me to change my behavior will require a reduction in verification cost of 40%, 50%. Blockchain may not generate that for you. It doesn't change anything. So it's literally a waste of money at that point. Here's another thing. There are very few examples of crypto use cases thus far. I hear about NFTs, right? NFTs can be useful, but again, the scope of this market, you have to wonder, like, how large is this? How many people really want Bored Ape apps? Or whatever else is the new thing in town. Or the Pudgy Penguin, that was the other one. That seemed slightly more interesting to me than Bored Apes, I don't know why. Here's another one that just fundamentally confuses me, which is, why do we need to pay verifiers on public blockchains in crypto? Why can't you just pay them in cash? Like you pay for everything else. Cash, stock, chickens, whatever. of something real, right? When I say real, it's not that I think crypto is unreal, it is that its value is derived from how many people use it, right? So the logic typically given by why you want, if a logic is given, sometimes it's not, people just throw their hands up, but to the extent there's a logic given, it's usually that if you want people to use the coin, you need to have it populate quickly through a network effect. Okay, well, there are lots of ways to think about that, right? One is, yes, network effects can be plausible. Do we really think all these crypto coins are going to have large network effects? That seems a rather heroic assumption. The other thing is not everything that has a network effect is good. A network effect is a thing, a tool. It can be used well, it can be used badly, right? It's not obvious to me that this is really a terribly strong argument. So when I think about crypto, which is really public blockchains funded by crypto for verifiers, is a very long way of saying crypto markets, I wonder how big is that market, right? If you look at who has patents on blockchain, it's people who have private blockchains. Why is that? No one in their right mind will get a patent on something they're going to give to the public for free. That's nuts, right? Private blockchain is where a lot of the activity is. The biggest patents, the biggest holders of patents on blockchain are banks, healthcare companies, and retail entities. They're the folks because they want to create networks within their entity to keep you in-house. Public blockchains are being tried. There might be some that work, right? There might be, I imagine there'll be many that fail. That doesn't mean they don't have value. It just means one might want to be slightly more skeptical about thinking about where is the value proposition in some of these things. Now, I should note, that doesn't mean securities regulation should prohibit these. Part of the point of having a mixed market economy that's somewhat capitalistic is experimentation, right? You've got to allow for that. Securities regulation is not about banning bad ideas. It's about giving information to people with some level of verification, of veracity, and trying to address conflicts of interest so that people can make their own decisions, experiment in their own ways, right? So let's actually try to do that. That might not be a bad idea. All right, concluding thoughts. They've attracted a lot of attention, these crypto asset markets, and raised many regulatory questions. As I mentioned, the central question is securities regulation. I think policy-informed discussion here is really important and is likely to lead to different regulatory prescriptions than the ones that are out there. That listing I gave you of different countries, I think they all are doing certain things that may not be supported by policy analysis if you look a little more closely at it. All right, SecReg is motivated by concerns with asymmetric information, gatekeeper, and so forth and so on. Case law doesn't seem to reflect much of that thus far. What happens when you do? It turns out that a lot of the concerns in crypto asset trading don't map on easily to federal securities laws. Doesn't mean you can't use it, it means you'll have to adjust it, right? You'll have to move towards perhaps different kinds of things that you want disclosed, different parties you want as your regulatory touch points and gatekeepers, and maybe even move towards ex-ante regulation, which is kind of an interesting way to go. Global regulatory regimes look like they're experimenting with different models, right? You see licensing regimes, you see taxing regimes, you see regimes that are in a state of muddling through, which is, I guess, the way to describe what's happening in the US. I think all of these might actually benefit from more explicit policy analysis. And that path may actually be quite useful when you start looking at other areas of law implicated by crypto assets, in particular money laundering and privacy, which in my view, and commercial law, which if this were to actually grow, I think would actually be the three areas of law that would be the most directly impacted. Tax for sure, but if you have a immutable ledger of transactions, taxing should not be that hard. In any case, I'll end there. I'll be delighted for a discussion, questions, and comments. Thank you so much.
I've just got a short comment and maybe a question. So in Singapore, I don't know whether any regulators are here. They said Howie doesn't apply. So for some reason, we've decided that for our collective investment scheme definition, which is not that different from an investment contract, Howie doesn't apply. But it might just be that that's fine because a lot of what you're saying seems to map, not totally, but to the fact that maybe we don't worry so much about the primary markets anymore in terms of disclosure and other things, but we worry about the secondary markets. And so things like, for example, knowing who are the big institutions involved, That sounds a bit like the substantial shareholder disclosures that you have for us here under the Act and Williams Act for you. So I'm just wondering whether maybe we should just give up the primary market regulation and the securities regulation becomes something about the, and I think you're hinting at that as well.
Yes, that's a great point. So, as many of you know, across the world, the size of primary markets seems to have become much less. The number of IPOs has diminished. The number of publicly traded firms has diminished, especially in the U.S. And one wonders how much value will be added, especially as you see more large institutional money entering the market, right? Everything begins to look more like a private market in some ways. So in that sense, I think that directionality is quite fascinating. An interesting counter development, though, of course, is that in some parts of the world now, we're seeing, especially the EU, a push towards making private companies disclose what public companies disclose under securities laws. Not necessarily a bad idea, but again, what the reasoning behind that presumably is that some of these private companies are huge. They look like they're shadow public companies in terms of size and impact. Maybe we should compel some disclosure. I have a sense that there might be an opportunity for a reckoning of what type of information and from whom do we want to get certain things. One of the interesting findings in the survey that we ran was we asked respondents, who would you want to provide information on things you think are important to crypto? And we sort of thought they would say exchanges or the crypto firms. They came back with, no, we'd like the government to provide it, which was an interesting dynamic, something we put the government in there as kind of like a joke option. We didn't think anyone would actually take it, but they did, which was interesting. My sense is that there's a broad rethinking of what do we want federal securities laws to do, or what do we want securities laws to do, and are the distinctions we currently make about how far they go the ones we really want to stick with. So I think that primary, secondary one is one of that broader category.
I think we've got microphones and just a brief introduction of yourself. Christian?
Well, thank you so very much for a really great talk. What worries me a little is this lack of guidance and leadership that's coming from the US, I must say, given that it draws jurisdiction over a lot of things very, very easily, as we know. And on the one hand, the categorization of crypto assets as securities, but then also as other things, and all the high risk of liability, criminal liability in particular, that comes with all of this. If you look at platforms, which really now are, as you were saying, at the core of regulation in many jurisdictions, they need to actually know what it is that they're actually, or the trade of which they're actually facilitating. The example of Sam Bankman-Fried, of course, is a reminder of this. If we see something as securities-like, then the default is there's a custodianship kind of relationship. That's the default kind of model. Otherwise, it's more of a loan kind of a thing, especially if it is money-like. And the consequences, of course, are tremendous. And therefore, what about, clarity and security reliability in jurisdictions like this one here, giving advice to someone running a platform, any kind of other facilitation of crypto asset related services, but there is a US dollar kind of component or the likes of jurisdiction of the SEC and the US courts actually could actually be construed. So can we expect that's a question for you, any kind of clearer guidance actually coming from the US side, at least some sort of a negative type of documentation that you're safe, you stay sufficiently clear of all the risks that come with something being categorized as a security. And as I was already hinting at, something being categorized as money or money-like with all the bank regulatory requirements and the like is a threat which is just as grave as the security one. Thank you.
Thank you, Christian. Do I expect regulatory or legislative clarity from the US in the next 12 months? Probably not. Not because I'm negative about that happening. It's just there's a presidential election next year. I suspect we won't see big legislation on that. Having said that, I like the idea of of the kind of the safe harbor you're hinting at. That is, there a way you can get a negative assurance that what you're doing is not violating the law? And securities law has many, many safe harbors in it. And one form of ex-ante regulation you could imagine is saying that the parties involved in creating or marketing a crypto asset, if they meet certain conditions, are essentially exempt from being subject to liability. I think that could be a model you could imagine. What those conditions are that would satisfy you so that you don't face liability, or at least the authorities are comfortable not coming after you, I'm not sure in the crypto markets yet. I mean, what is a kind of due diligence or compliance or whatever you'd expect people to do, right? But having said that, that is certainly one way to get around the gatekeeper issue, which is let's throw the net to everybody. Everybody's involved, but if you meet these requirements, we're going to say you're not liable. That could certainly be a way to bring in ex-ante regulation, but to keep the net broad. Having also said that, it is interesting that the US has been very reticent in legislating or even regulating in this area. The SEC has not put out any rules. The CFTC has not put out any rules. The only parties that have put out any rules have actually been the Fed and the banking authorities. They've attempted to do something in this area. Even there, it's not entirely clear what this thing looks like. I suspect part of it is there's a lot of smoke and mirrors in some ways about what exactly is the product that's being offered. I mean, even some stable coins is probably the clearest example of a crypto asset of, that's not a private blockchain. But even there, what exactly that is, when is it valuable, how is it better than digital currency produced by the government? It's much more vague, I think. I suspect part of the effort that was going on before all the frauds came to light was to actually try to capture being the wrong, it has a political connotation, let's say, to influence the process of designing regulation. I think people in the crypto world seem aware of the fact that some kind of regulation is essential to grow the market, but they all want to have influence in it, as one might anticipate. And how that emerges and develops, I think, is extremely contingent. I mean, last year at this time, Sam Bankman-Fried was the person who seemed to be driving a lot of crypto regulatory agenda. He's now in jail. And facing sentencing in about 3 months. I think it's going to take a little bit of time. I think also when you have more plausible use cases, I think it becomes easier to actually legislate because you have a target. Right now, some of the use cases seem almost esoteric at times or ephemeral. As they become more concrete, if they become more concrete, I think there it's easier to think about, okay, how do I try to regulate this? It's concrete. I can see where the things are. I can feel it. As I sometimes tell my kids in particular, it's much easier to make a pizza if you feel the dough in your hand. Otherwise, I'm inclined to order from Domino's or whatever is a pizza place. So.
Lance, and then Kelvin.
Yeah, hi, thank you for your talk. I'm just having a question. It seems like, I mean, most of the regulatory debate in the US right now really is still centered on whether crypto is security, but I think the debate in Singapore and Hong Kong has moved on with respect to regulating crypto, particularly stablecoins, as means of payment.
Yes.
So I'm just wondering, what are your broad thoughts as to the differences in this regulatory approach and the benefits of actually regulating crypto as payment instruments, notwithstanding the risks to the monetary system?
Yeah. So that's a good point. I mean, and it is fascinating in the U.S. The focus has been on securities laws because cryptos are traded so actively there, and there's so many institutional investors that are trading in those sectors. I also think because a lot of the exchanges that are public entities are publicly traded companies are in the U.S., there's been much more push in that direction. But crypto as payment is actually more of a use case, right? So you're actually looking there as not as a trading mechanism to get something else going, but as a use case. And I think that makes it a little easier to regulate in some ways because you can kind of see it being used. It's not a derivative in a sense, it's a real case scenario. Now, on the payment side, it's fascinating to me in some ways because I spent a decent amount of time looking at the Indian markets, and in India you have the uniform payment interface. And I remember like a year or two ago, a lot of crypto companies went to India thinking that they were going to bring a brilliant payment methodology to India. Their thinking was that there's so many remittances from abroad to India that this would be an amazing market for them to target. And they believed, perhaps a little bit over-enthusiastically, that there were 100 million people in India that own crypto. So they went there and they discovered that there's this uniform payment interface and nobody in India cared about crypto as payment, as a payment service. They just like, who cares? And the reason is simple. The uniform payment interface is extremely efficient. It is very, very effective. It has penetrated the market in India incredibly well. And the notion that you would gain a lot by adding a blockchain verification technology on top of UPI, I mean, it's maybe you get a little bit better, quicker verification, but no one is buying, milk worried about the nanosecond difference. It's trivial. It basically died on the spot there as a payment methodology. They view blockchain as being useful for other things like healthcare records and stuff like that. It's actually an interesting point because I do think that the value of the technology varies so much on what is the pre-existing state of affairs. In India, payment services are quite efficient now, so it doesn't really matter. In the US, payment services are arcane. And it seems to me that would be a great market to go more into. In other countries, I think it's more in the middle. And I think, again, that's more like getting back to the basic question, which is, what are the other technologies to do this? Whatever it is you're trying to do, whatever you're trying to verify. Now, in terms of the regulation of money payment structures, so I hesitate a little bit because when countries are moving towards digital currencies, the value of crypto-based trading doesn't seem as high. Now, there are arguments being made that, well, one of the values of crypto trading is you don't have the central governments involved in monetary policy as much. So without taking a position on whether central governments do a good job or a bad job of managing money, which I'm not inclined to take a position on since that's not my area, I will say this, as a real politic matter, going to an established economy and telling their government that we're going to manage monetary policy better than you is the equivalent of telling them that give up 1/3 of the influences on power you have. I think it's highly unlikely that governments will find that argument persuasive. Indeed, their incentives are not to find it persuasive. But beyond that, I don't know if I have much to say. I think it varies tremendously with the institutional structure you're already looking at.
Calvin?
Right. Sort of a comment and then a question. So on the verification point, I think you'll find that the technology is quite limited in terms of what it can actually verify.
Yeah.
So for example, if I wanted to find out whether Ming Sing owned particular crypto, he would have to sign his private key.
Yes.
Now, the problem with that, of course, is that the blockchain consensus protocol cannot tell whether it was Ming Sing that signed his private key or Ming Sing's dog that did it. So that's utterly useless, which really shrinks the possible use cases very dramatically. I'm quite interested in your survey. Were the respondents primarily people who have already invested in crypto? Because these people are some of the most gullible people around, and it strikes me as they're probably not the best people to ask as to how you think you should protect yourself. So as an example, there's a documentary on CNBC about a couple of people who have lost money investing in FTX.
Yes.
And one of these people was, I'm going to sell my bankruptcy claims and go all in on crypto because it's going to come back. So I'm a bit concerned about asking these people how we should shape regulation.
Yes. So that's a great question. So our survey was based on trying to get a representative sample across the United States. So actually we targeted people who didn't own crypto as well as those who did. And so in our respondent pool, I'd say about 16% said they had either owned or currently own crypto. The responses we got were different than what we would have expected. So the first thing is very few retail investors invest a lot of their portfolio in crypto because they're not crazy. That's good. Some might be gullible, but they're usually not completely crazy. The second thing was that the aversion to regulation, that is, they didn't think regulation helped them much, was stronger in the pool of people who did not invest in crypto than in the pool of people who did, which is the exact opposite to what you would expect, because the perception of those who invest in crypto is that they're kind of like, market rules kind of dynamic. And instead, they actually were more inclined to think regulation might be slightly useful, although not by much. But the people who did not invest in crypto, by and large, thought regulation was a giant waste of time, which was exceedingly depressing to me as someone who teaches in this area. I can only take that as an indication that they think that regulation is not being enforced well or is being designed badly. But that seemed to be the dynamic. Now, on the underlying technology point, I think that's a very fair point, which is if you look at a lot of blockchain-based verification, some of the consensus protocols seem almost laughable. Like, what are they, how is this supposed to work? But then some consensus protocols seem not bad. I think there's a lot of experimentation going on there. I will freely admit that I'm skeptical about public blockchains being the best way to verify things, except maybe in a handful of very small, narrow situations. Private blockchain consensus protocols are a little different. They run on a different dynamic, I think. And their incentive structures are different. I think the reason I like the idea that they don't get paid in the underlying digital asset is it removes one of the biggest sources of conflict of interest. Because if you're getting paid in the currency that you're verifying transactions in, your incentive structure to me just doesn't look fully right. But if I'm getting paid cash to verify something, that seems a little bit better. Not perfect, but better. I think a lot of the consensus protocols and the different crypto coins, I think there's a lot of experimentation there. I'd be curious to see if they actually begin to dovetail towards particular standards. My impression is they, with Bitcoin, they have proof of work, and then with others, they have what they call proof of stake. In the proof of stake world, a lot of these things don't look like they're actually that standard, and they don't strike me as being, some of them don't strike me as being credible at all. But then again, I'm not an expert on what is the best consensus protocol mechanism. I will say I do find it fascinating that when one thinks about how market prices are set in certain things, that operates on a version of a consensus protocol, actually. And I've seen very few people who look at blockchain technology that attempt to adopt that version, which I think is intriguing. I think partially it is because they may not understand fully the institutional structure of market pricing, but it may also be because it's really hard to replicate the institutional structure of market pricing, which was built up over hundreds of years in weeks or whatever it is their time frame for doing things. I had at one point thought about doing a project where I looked at GitHub. If you're familiar with GitHub is where a lot of people who write protocols for public blockchains put their protocols. And it was interesting because it was just all over the place. I mean, it looked like what you would expect when you had no property rights in what you were writing. Random thoughts in certain directions. Other things were very clear. Others were just all over the place. So yes, if the concern is that a lot of blockchain protocols are going to be nonsense, I absolutely agree. Indeed, I might even venture a guess that the majority of them are, at least of the ones I've seen. But I don't think that means that none of them will be valuable. I think in certain contexts they might be valuable. I'm just not sure that using crypto to pay verification is going to be a very high yield proposition, at least not yet.
Thanks, Vikram. I think we are out of time. So it just remains for us to thank Professor Khanna once again for a wonderful talk.
And thank all of you for your questions again.